This is actually a general talk that I've put together around public law and where it intersects with housing, which is in quite a lot of it. This is the area of law that I just think is fascinating because it's where the individual meets the state. So we've got that real mix of law and politics, and it's really decisions that impact people's real lives and also take account of those real life considerations about resources, impact on not just the individual, but the broader public good. And it's really where all of that comes into the balance and comes into question. So the reason I've put this talk together in the way that I have, I really wanted to give a broad brush overview of this area for a number of reasons. And the first one being that really so many parts of this overlap. So if I just was speaking about the Human Rights Act, it would miss out so many of the other elements where, as you'll see when we start to look at some of the case law, a lot of the times you'll have things pleaded on public law principles with a Human Rights Act element, with an Equality Act element, all around one set of facts. And that happens time and time again. So really what I wanted to do is give a very broad brush overview so that you can start to get an idea of how some of these things fit together. I personally just think it's really helpful as well to see that bigger picture. And it helps with maybe making some tactical choices when you're looking at how to plead a case or how to defend it, on which way to go. And I wanted to start all of this by saying that in this area of law, public law generally, the emphasis really is on procedural fairness and legality and not on the outcome of decisions. Now, that means that primarily when a court looks at this and when you as people deciding whether to bring a claim and how to defend a claim are looking at this, what you should really be looking at is, have correct procedures been followed? And are people acting within their legal powers when they're making decisions? It's not a, do we like this decision or not? Your client might not like the decision the local authority has come to in relation to whatever duties they're owed, but that doesn't mean you have a strong public law case, or certainly you won't have one if you plead it on that basis. You've got to look at what's happening underneath and the real process and procedure, because ultimately, when a judge looks at it, that's what they're going to be looking at. Even if a judge thinks, actually, for example, this tenant or this homeless applicant should have had a different duty met by the local authority should have done something different in their view, that doesn't mean a judge is going to overturn the decision as long as you as a local authority or public body have followed the correct procedure. And I think it's particularly helpful, like I said, not just for claimants in deciding whether or not they've got a claim and how to plead it, but also if you are a public body, a local authority or otherwise, it's important to note that really, because this is all process driven, it's for you to do preventative work, focusing on your policies and processes, so that even if people don't like the decisions you're making, which with the best will in the world, there are going to be people that don't, you've bulletproofed yourself, or at least done the best you can to armour yourself up against these kind of claims. So moving on to who can be challenged. Judicial review and public law generally challenges the decisions of public bodies. I've put a couple of cases up on the slides, which are two of the most relevant ones to housing. The first one is the case of Weaver, which is a Court of Appeal case from 2009. It's where it was decided ultimately that registered social landlords, charities, companies and cooperatives that provide social housing should be treated as public bodies and subject then to the Human Rights Act and to judicial review generally. The key questions that were considered were how the organisation were financed. They were financed publicly. Does the organisation assist the local authority to fulfil its statutory duties? And they were providing social housing. And does the organisation, provide social housing? Now, that's an interesting case, and it did go, an application was made for appeal up to the Supreme Court. The Supreme Court, when they knocked it back, said this is a point that they would wish to look at again, but not on the facts of this particular case. So as much as a lot of the time this is sort of felt like, well, this is set in stone, Weaver, yeah, public body, crack on. It's actually not as simple as that. And a lot of the sort of literature and journals that you read around it are basically saying, what we're waiting for is for a landlord, public body, who's been deemed to be a public body, to bring an appropriate challenge. Now, because of the amount of money it takes to take a case to the Supreme Court, that hasn't happened yet. But I would say at some point it more than likely will. And I've also cited the case of MacLeod and Peabody, and that's because it shows really how applying those three principles that were picked out in Weaver about finance, about assisting the local authority, and about what sort of housing was provided, a very different decision was reached. In that case, Mr. MacLeod was a tenant of Peabody, and he was seeking to exchange his tenancy, he was based in London, with another tenant up in Edinburgh. When that decision was refused, he brought a claim for judicial review and argued that Peabody's decision was unlawful because of the process by which it was reached. The High Court in that case decided that actually the Peabody Trust didn't meet the criteria to be a public body, and that was because the property that Mr. MacLeod lived in, the funds to purchase it were raised on the open market, so it wasn't publicly financed. It wasn't pure social housing. There was no allocation relationship with the local authority, and the rent for the property wasn't subject to the level of statutory regulation that would be for social housing. So the level of rent in this case was somewhere actually in between the level you'd expect for social housing and on the open market. Just a note on that, because certainly in my experience, that's a point that is almost never challenged anymore, and it could be. Now, I want to move on to talk about ways in which these public law principles that we're going to come on to look at might become relevant. And the first way in which that can happen is that these principles, whether it's Human Rights Act, Equality Act, general public law principles, or other statutory duties, can be relied on as a defence in possession proceedings. Now, there had originally been two ways in which they'd be relied on, Gateway A and Gateway B. Gateway A challenges the legality of the law that allows the possession or eviction proceedings in the first place. So you're looking there, for example, at people making applications, declarations of incompatibility under the Human Rights Act. The more relevant gateway to what I would assume, well, in most cases, and the more relevant gateway to most of you would be Gateway B challenges, which challenge the specific decision to evict someone and challenge it on the basis of it being unreasonable or disproportionate. The leading case in this area where that Gateway B criteria was widened is Doherty and Birmingham City Council. Before that case, it was only in relation to unreasonableness. You had to prove that something was Wednesbury unreasonable before you could bring a broad public law challenge in relation to possession proceedings. In that case of Doherty and Birmingham City Council, the House of Lords determined that actually, effectively, if you could GR it, or if it would be valid as a GR, then you can bring it as a defence to possession proceedings too. Now, Court of Appeal case, Barnsley, MBC and Norton. And the sort of corollary to the point that if you can GR it, you can use it as a defence is this point in Barnsley, which is that a public law defence will only succeed where a judicial review would have succeeded. Now, I'm highlighting this particularly for those of you who might be defending these kind of public law defences, so acting for landlord public bodies, because very rarely, if ever, in replies and responses when these defences are raised, do I see anybody saying, providing really a substantive defence. They'll effectively go no further often than just a simple denial that they've breached a policy. They won't set out a proper basis for defending those points. So, for example, one of the key points would be under the Senior Courts Act, Section 31, a judicial review cannot succeed where it's highly likely that the outcome for the applicant would not have been substantially different if the conduct complained of had not occurred. That's the wording from the statute. In effect, if you're able to argue that, look, even if we'd followed the policy, we would have come to the same decision, or even if we'd considered X, Y, Z, whatever public law principle or duty you're relying on, nothing different could have happened, then you need to plead that. The main reason for that is that it won't be considered at all unless you plead it. It's unlikely to be considered. Moving on, I'm going to touch on Section 204 Housing Act appeals, which is the other area of where these public law kinds of arguments are going to be routinely seen. Effectively, Section 204 is like its own little mini judicial review scheme that applies in homelessness and homelessness decision making. It follows from Section 202 internal reviews, and Section 202 of the Housing Act 1996 sets out specifically those cases that are subject to the internal review scheme. So decisions that can be challenged via Section 202 and Section 204 generally tend to be things around whether an applicant actually is homeless, is eligible, is in priority need, or is intentionally homeless, as well as any decision to end any of the housing duties, the prevention duty, the relief duty, and the main housing duty. And then one of the key ones that comes up really often under this heading is suitability. So suitability of housing based on affordability, based upon location, condition of the property, size, its ability to meet whatever health needs. As in with judicial review, if an appellant under Section 204 succeeds in bringing their case, what usually would happen is that an early decision is quashed and whichever local authority has taken this decision would need to retake it. There is, in Section 204, a real deference to the decisions of local authorities and homelessness teams. So they're seen to be the experts, just as in judicial review. It's not going to the facts, it's going to points of law. Judges aren't going to step in and override a decision, a factual decision that's been taken. They're looking at the process. That means it's a pretty high threshold for one of these claims to succeed, or it should be. The difficulty is, and sort of the positive, if I can put it that way, for people who are seeking to bring these claims on behalf of appellants is that very often, and whether it's because of a lack of resources or however policies are being implemented in local authorities, the local authorities aren't making their decisions or evidencing that they've made their decisions in a way that makes it easy for them to be kicked back. So there is on the face of it an easy kickback. Yeah, we followed the process. But very often, that's quite hard for these local authorities to be able to demonstrate. And the final place where these public law arguments are going to be relevant is within judicial review proceedings. And just briefly in relation to judicial review, it's really a remedy that has been created by judges. It's being created really post-World War II in the way that we know it, as a result of the fact that the state was becoming more and more involved in people's lives. We've got things like NHS, welfare state, housing, immigration, education, all of that post-World War II meant judges decided that there needed to be a way to put a check on that power. There were just more places where an individual could come into conflict with government decision making. So in the 60s and 70s, primarily, judicial review as we know it was developed. It is underpinned by statute. I've already mentioned the Senior Courts Act 1981, but in spite of it being underpinned by statute and as well as set out in detail a lot of the regulations and procedural rules around it in CPR Rule 54, Part 54, case law is really where you're going to find the majority of the rules and practice, I guess, of judicial review. Generally in relation to homelessness, and I'll focus on that, judicial review can be used to challenge decisions on whether or not to accept a homelessness application, decisions on providing interim emergency accommodation, and suitability of interim and emergency accommodation. Now, I'm going to move on next to looking at some of the ways in which, so if you're bringing a judicial review, a Section 204 housing appeal, or you're wanting to defend possession proceedings, some of the different public law principles and other means by which you might start to build your arguments. And the first way is generally by looking at public law principles. So these are the sort of things that would usually form the grounds of judicial review. And I've put it as plainly as I have there because I think as much as once we unpack it, it can become quite complicated. Essentially, this is what we're looking at when we're looking at public law defences generally. And like I say, grounds for judicial review. Has the decision maker acted lawfully? Have they followed the law? It should be quite simple. Have they acted fairly and have they acted rationally? Acting lawfully first, that's where you might start to bring in breaches of various statutory duties, the Equality Act, Human Rights Act. And moving to acting fairly, I did want to bring your particular attention to the case I've put in the handout, Croydon LBC and Barber 2010. This really highlights the point in relation to the need to comply with written policies. And again, it's a warning bell for those of you acting for public bodies, but also sort of a roadmap really for those of you wanting to bring claims or defend claims on these basis. Because in that case, what had happened, it was a non-secure tenant who'd been served with a notice to quit after an incident of violence. A medical report, expert report, then confirmed that he had mental health diagnoses which were causatively linked to that incident of violence. And the council's decision was found not to have applied their vulnerable people policy, and therefore it was Wednesbury unreasonable. An important case that shows how these sorts of principles can be brought to bear. And I'll move on then to the Human Rights Act. Again, there's lots of overlap, not just with the various articles of the Human Rights Act, but within the Act, how you might plead something. So what I would say is it's important to keep in mind that if you're pleading a breach of one of these things, have a look to see whether it actually fits as a breach of one of the others too. Now, the key case here is the Pinnock case, where it was decided because of a clear and constant line of jurisprudence in the European Court of Human Rights, that the courts would have to have the power to assess the proportionality of making possession orders. And in making that assessment, if need be, they're able to resolve any factual disputes between the parties too. Now, in making that decision, which was a departure from the previous legal position, the court set down 6 sort of principles that to keep in mind, or that would need to be kept in mind when making assessments. The first is that in relation to Article 8, it only comes into play where a person's home is involved. Proportionality is only in question if the point is raised by the occupier. Any Article 8 defence should initially be considered summarily. Now, that's something that is relied upon time and time again when I've seen public bodies seek to defend this point under Pinnock and Article 8 challenges that are brought under it. It's really important for both sides to make sure that they've set out their case as fully as possible for this reason. And certainly, in my experience, I've not actually seen anyone succeed yet in the cases I've been in as a public body in getting this summarily dismissed. And often, in my view, that's been because it hasn't been taken seriously enough. They've seen this, consider it summarily here and thought, oh, well, it's only going to be given short shrift. And that's not necessarily the case. And the other matters of relevance from Pinnock is that an Article 8 argument, it's not just that it might mean that the judge refuses to make an order altogether, order for possession altogether. It can also mean that a judge can consider suspending any order. And it can also be used as a basis for arguing that any period for possession is extended as well. So I'm thinking of mandatory grounds where you wouldn't normally get that extended period. Even if you don't succeed on arguing that there shouldn't be possession on that mandatory ground, it might well be worth pleading if it's going to mean that your client gets an extra month or 2 in order to get themselves further housing sorted. And the final point I'll highlight from Pinnock is that it made clear that Article 8 proportionality is more likely to be relevant in respect of occupiers who are vulnerable due to either a mental or physical disability. I want to focus in what I'm going to talk to you about, just about the public sector equality duty. And really, that public sector equality duty is one that's pleaded often and one on which I have seen cases succeed. It's not a duty to achieve a particular result. So it comes back to what I was saying earlier, that this is really procedure focused. It's have you considered, in this case, have you had due regard to achieve the results identified in section 149? And it is a continuing duty. So, for example, if at the outset you know of somebody's disability, and then in the intervening period on the run up to trial, you've received a medical report that gives you much more detail, that expand on the diagnoses or whatever, you need to really be revisiting your decision because you've been given more information. And if you haven't considered this and reconsidered proportionality, it would certainly be a matter that I would expect to be being challenged by the time any case comes to trial. And I'll also highlight a case brought under the Equality Act as well as the Children Act, AK and Westminster Council 2024, EWHC 769. Now, in that case, the applicant succeeded in demonstrating that Westminster Council's policy was indirectly discriminatory, contrary to sections 19 and 29 of the Equality Act. It also managed to demonstrate that Westminster had breached its public sector equality duty and had also breached its duty under section 11 of the 2004 Act. Now, the case was about allocations, and it was brought by female survivors of domestic abuse who were seeking to relocate to the area. And effectively in their policy, what Westminster hadn't done, although they'd reviewed it a couple of times, the policy in its main bulk had been written in the 1990s. So it didn't, the PSED wasn't even around then. It couldn't have been said to have been considered. It wasn't in the policy. And the way the policy was worded, it meant that survivors who were seeking to move to different local authority areas were disproportionately impacted because the policy itself was favouring people from within the local authority. Now, very clear takeaways there from both sides of the fence. If you're acting for a public body, you need to make sure that when you're reviewing your policies, it's not a quick read over and actually you're working with something from the 1990s. You need to make sure that you're actively considering Human Rights Act, Equality Act, and these public law principles as they are developing and as the case law is moving. And if you're acting for a tenant seeking to bring a challenge, absolutely, you should be digging through these policies. The last thing I'll mention are some of the statutory duties. And I've put here the Children Act, the Care Act, and the Mental Health Act 1983. And I'll just highlight one case that I think is particularly interesting, and that's the case of Davies and Hertfordshire County Council 2018. In that case, it was pleaded that there was a breach of Article 8 and Section 11. And when the judgment was given, it was made very clear that the reason that there hadn't been success on Section 11, it was conceded that it didn't look as though the local authority had really considered it. But the reason there hadn't been success on Section 11 of the Children Act relates to the need to ensure that the welfare of children is safeguarded and promoted in carrying out functions. What hadn't been done in that case was any information or evidence to actually demonstrate the point. So effectively, this chap in his application or in his defence of possession proceedings had said, well, you haven't thought about the impact on my child. Well, yeah, but what's your evidence of the impact? Provide us some evidence that there is going to be an impact. So you need to back up these points. Moving on from that, just to some top tips for bringing claims, and it really links in with that last point. Don't treat these public law arguments as an afterthought. I think certainly from what I see, because they're not the first port of call and they tend to be where you go if other defences aren't available, they're often just what it looks like is bashed onto the end of pleadings, and they're not properly pleaded, they're not properly thought out, they're not, as in that Davies case, properly evidenced. And case law is there to show that actually, if you do that bit of extra work, whether it's digging through a policy, whether it's going and getting that evidence that actually the local authority haven't discharged their Care Act duties or haven't considered the welfare of their children and it would have been relevant, you can succeed, but it just takes that bit of extra legwork. And linked to that, of course, is just this point of pleading it as fully as you can. Time and time again, I see defences to possession proceedings, for example, pleaded with breach of the Equality Act. Well, which section? And break it down. What are you saying's happened? What's gone on? How are you saying that this section is made out, that this defence is made out? So I'll move on to top tips for defending claims. The first one is pretty clear, and it's record decision making. And I'll tie this in with what's been said already and at the next point in relation to proportionality. so often when I see and act in cases where there are public bodies and local authorities, when we get to court and I'm speaking to the witness for the local authority, the head of the housing team or homelessness decision maker, whoever it is, it's very clear that they've understood what the different things that they need to consider are, but nowhere has that been evidenced. And if it's not in writing, it's just often by the time we get in the witness box, sometimes you can claw it back, but it makes a very easy point of saying, well, yeah, you're saying that now, but where is that in your documentation? The other point on that, and I see it again, time and time again in minutes from decision-making meetings, but particularly in proportionality assessments, it's a failure to actually consider proportionality. So in order to say that something's proportionate, you have to have considered both sides of an argument. And what I see, and it's because the people that are making these decisions, they aren't lawyers, they're just often, from what I see in my reading of it, writing down the reasons that they say that they're right. Now, that's not a proportionality assessment, that's an argument as to why you say your decision's right. And what that does is make a really easy point for, if I'm acting for the tenant, for me to come in and say, well, yes, but you haven't actually considered the impact on them because they haven't put it in the decision. You haven't considered this medical report. You haven't considered whatever it is, all of the points that the tenant is raising. They need to be able to say, well, look, yes, I've actually taken account of what their GP says. I know they have this diagnosis. I know it's going to have this impact on them. But even taking that into account, I have decided to give weight to these other considerations, the impact on the community, the impact on our resources, whatever it is. And that really is the way to make sure your decision making is going to be more difficult for a judge to interfere with, because what they can't do, unless you've done something really unreasonable, is step in and override the way that you've given weight to decisions. It's all about showing that you've followed a process, which if you've considered both sides is going to be much easier.